Antonio Armstrong Jr. stands charged by indictment with the offense of capital murder, alleged to have been committed on or about the 29th day of July, 2016 in Harris County, Texas. The defendant has pleaded not guilty. A person commits the offense of murder if he intentionally or knowingly causes the death of an individual. A person commits the offense of capital murder if he commits murder, as hereinbefore defined, and the person intentionally or knowingly causes the death of more than one person during the same criminal transaction. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. You are instructed that it is your duty to consider the evidence of all relevant facts and circumstances surrounding the deaths and the previous relationship, if any, existing between the accused and Antonio Armstrong Sr. and the accused and Don Armstrong, together with all relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the alleged offense. Now, if you find from the evidence beyond a reasonable doubt that on or about the 29th day of July, 2016, in Harris County, Texas, the defendant, Antonio Armstrong Jr., did then and there unlawfully, during the same criminal transaction, intentionally or knowingly cause the death of Antonio Armstrong Sr. by shooting Antonio Armstrong Sr. with a deadly weapon, to wit, a firearm, and intentionally or knowingly cause the death of Don Armstrong by shooting Don Armstrong with a deadly weapon, to wit, a firearm, then you will find the defendant guilty of capital murder as charged in the indictment. Unless you so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. You are further instructed that if there is any evidence before you in this case regarding the defendant's committing an alleged offense or offenses other than the offense alleged against him in the indictment in this case, you cannot consider such evidence for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense or offenses, if any, and even then you may only consider the same in determining the motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident of the defendant, if any, in connection with the offense, if any, alleged against him in the indictment and for no other purpose. Our law provides that a defendant may testify in his own behalf if he chooses or elects to do so. This, however, is a right accorded the defendant, and in the event he elects not to testify, that fact cannot be used or taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are further instructed that the state is not bound by the specific date which the offense, if any, is alleged in the indictment to have been committed, but that a conviction may be had upon proof beyond a reasonable doubt that the offense, if any, was committed at any time prior to the filing of the indictment, which is within the period of limitations. There is no limitation period applicable to the offense of capital murder. A grand jury indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the question of guilt of the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that he has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and the weight to be given their testimony. But the law you shall receive in these written instructions, and you must be governed thereby. After you retire to the jury room, you should select one of your members as your foreperson. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by using the appropriate form attached hereto and signing the same as foreperson. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. No one has any authority to communicate with you except the officer who has you in charge. After you have retired, you may communicate with this court in writing through this officer. Any communication relative to the cause must be written, prepared, and signed by the foreperson, and shall be submitted to the court through this officer. Do not attempt to talk to the officer who has you in charge, or the attorneys, or the court, or anyone else concerning any questions you may have. Your sole duty at this time is to determine whether the defendant is guilty or not guilty under the indictment in this cause, and restrict your deliberations solely to the issue of guilty or not guilty. Your verdict must be a unanimous vote of all members of the jury. Following the arguments of counsel, you will retire to consider your verdict. It's signed Kelly Johnson, Judge of the 178th District Court in Harris County, Texas. The last page is the verdict form, and there are two options. First, we, the defendant, find the defendant, Antonio Armstrong Jr., not guilty. Or, we, the jury, find the defendant, Antonio Armstrong Jr., guilty of capital murder as charged in the indictment. All right, State, do you wish to make an opening?
Yes, Your Honor.
All right, you may proceed.
Six years. It has been 6 years since Antonio and Dawn were murdered. The little girl who was 12 years old at the time, is now in college. The better half of the last 6 years, their oldest son, Joshua Armstrong, has been in and out of psychiatric centers trying to get his life on track in the wake of his parents' death. And for 6 years, the person who is truly responsible for this crime has not yet been brought to justice. This case is a parent's worst nightmare. To come to the realization that the person you brought into this world would end your life. But that's what happened in this case. And the defense agrees that that's what happened too. Their only disagreement is which one of the kids did it. Now, the reason that the state and the defense can agree on this is based in common sense. It makes no sense that somebody outside the immediate household would bust into a house with the alarm system on and peruse the house to find the homeowner's gun, shoot the homeowners, go downstairs, take the time to write a note, and then lock up the house. And they know it doesn't make any sense either. So the number of people who could have committed this crime is limited. Let's talk about the evidence from that night. And we talked a little bit about it in opening, but now that you've heard it, you can put it in perspective. What's not on here is, at 9:52 p.m. that night, Kayra Armstrong set the alarm. She set it from the second floor panel in the house. What you've heard from the evidence, even from Kayra, is that Kayra went to bed. The Armstrongs went to bed. The only person in this case who was in the house who did not go to bed was the defendant. He was in his room on the third floor of the house. At 1:02 a.m., the defendant's cell phone activity stops. Why is that important to you? Because you see this? State's Exhibit 150. These are just the text messages between him and his girlfriend that day. Just her. He was on his phone constantly that day. The only time he was not on his phone was in the 38-minute window his parents were getting murdered. So we know from the defendant's cell phone dump, at 1:04, he plugs in his phone on the third floor. We know from the cell phone dump, at 1:08 a.m., the defendant takes his phone off the charger. Now, from his phone dump to the alarm records, you see how they work in conjunction with one another. After he takes his phone off the charger at 1:08, 1 minute later, at 1:09, upstairs motion detector is activated. And clearly, if it activated, that means it caught somebody. Now, at 1:25 a.m., we know that the living room sensor downstairs was activated. Now, the defense is going to get up here and they're going to tell you that there were issues with the motion sensors. I want you to recall what their argument was. They said the motion sensor on the first floor should have been going off more. But do you know what they base that argument off of? Do you know what they give credibility to? The doors. Because in order for them to say, well, the doors are open and closing, and therefore we should see more motion activity from the first floor sensor, they have to acknowledge that the doors were working. They haven't even touched that. They haven't even touched the sensor on the second floor. They haven't even touched the day in question. and you saw a person with them who came up here and was taking notes, if those doors weren't working the night in question, you would have heard about it.
Objection. Improper jury argument. The shifting of the burden. It's a comment on a witness that didn't testify.
All right, sustained.
Ask the jury to disregard the last statement of the prosecutor.
Ladies and gentlemen, disregard the last statement by the prosecutor. Please proceed.
Move for a mistrial.
It's denied.
And instruct the prosecutor to stay within the record.
Okay,
Stay
so,
within the record.
yes, Your Honor. So, if you want to take out the motion, this makes a lot of sense. Because we know in this time period, somebody had to go in the room to shoot Don and Antonio Armstrong. We know after that, somebody had to go put the gun down on the first floor. So this makes a lot of sense. But even if you disregarded the motion sensors, the bigger piece of evidence is the doors. And what we know and how you can double check and know that this is accurate, remember the 911 call at 1:40 a.m.? It was 16 minutes long. And at the end of the 911 call, you hear the defendant open the door and he says, "I'm the one that called." And what do we see in the alarm records? And he tells the police this in his statement too, that he turned off the alarm. And then we know that that was true because at 1:56, the panel was disarmed and then he opened the front door. And the records show he opened the front door. And even more than that, remember the testimony from the officers? They came in the house and they went to the back door and opened the back door. And we see that in the alarm records. And in between the time where Don and Antonio Armstrong are being killed, there is no evidence that those doors were ever open. In an opening statement, the defense team got up here and had you all stand up and look at this scenario where, well, if the door was cracked open, then it's possible somebody could have come in and not set the alarm or triggered the alarm. There is no evidence that that was ever the case. None whatsoever in this case. So let's talk about the people in the house, the immediate household. We know that there was only 4 people in that house. 2 people were shot in the head and 2 people walked out of the house. And neither one of them were named Josh. And you heard from Kara, I think it's all clear to all of you, she didn't have anything to do with this, and they know it too. There's only one other person in the house, and that person was awake when this intruder came in and killed his parents. Now, the defense has a theory in this case, but when you logically think about what their theory is, it's ridiculous. Here's what they want you to believe. They want you to believe that Josh Armstrong, suffering from a psychotic disorder, left his girlfriend and his cousin. He put on a mask to go to his own parents' house. He got in through the garage, which we all know is going to make a lot of noise. He didn't trip any alarm. He then went up to the second floor, all under psychosis, and he went and found his dad's gun in the nightstand, a gun that there is no evidence Josh Armstrong has ever touched or fired. He then, of course, had to make sure the gun was loaded and ready to go. After that, he would have went back around the other side of the bed and killed his biological mother first by putting 2 bullets in her head. Something that the defendant even told you in his statement how close Josh and his mother were. He said that they were identical people. So, after that, the defendant then would shoot his dad in the head. And then, here's where it gets good. Within the next 5 to 6 minutes, still under a psychotic episode, Josh Armstrong put pillows over his parents' faces. He went downstairs. He opened up a bunch of drawers in the kitchen. He took out a pen. He took out a notepad. and he tore the note off the notepad and he wrote a note, and then he scribbled over it several times to mask his handwriting. He then left the note, put the gun down, left the house, locked everything up, and put the garage door down. And he did it without leaving a trace that he was there. And then there's even more. Then Josh Armstrong goes back to his house, and I guess he stays there and waits for a call from his brother. And when his brother calls him, he comes back to the scene, still in this psychosis, and he draws attention to himself with the police officers by being upset and asking rational questions. That's what they want you to believe happened in this case. And I don't mean to make light of the situation, but at some point you have to ask yourself, did Josh Armstrong do this in the throes of psychosis? Or was he Tom Cruise in Mission Impossible? Because it's not both. I want to shift gears a little bit and talk to you about the text messages. You saw a lot of evidence in this case regarding text messages. And the defense tells you, oh, that's why the state wants you to believe he killed his parents, because of his marijuana use, because he was getting grounded a lot, doing normal 16-year-old things. We never said that was the motive for why he killed his parents. What motive would there ever be to kill those two wonderful people? The reason we showed you the text messages is that you could understand what the victims had to say about him, what the people who were locked away in that house thought of him. And what you know now is that the people who knew him the best, the people who brought him into the world, especially his mother, often referred to him as a habitual liar and somebody that schemes, and they didn't trust him. And they didn't have that issue with the other kids. So the defense will go on and say, if you look at the messages, especially the week of with his girlfriend and his parents, everything was great. No issues, not being disrespectful to his parents, everything was fine. That's our point. That's right. He was engaging in extremely destructive conduct in the house, and he did it with a smile on his face. Now, talk about behavior. They want you to judge Josh because he didn't go to the hospital the night in question and say that means he had something to do with the murders. Can we talk about the defendant for a second? What kind of person takes on the persona of a normal, happy person when he's clearly experimenting with ways to kill his parents? And then you heard from the psychiatrist, you heard his interview. That's not shock. What we heard from the defendant, that wasn't shock. So what kind of person is that? Speaking of the interview, did you notice he has absolutely no concerns about anything that happened that night? If you listen to his interview, he's not concerned about what the evidence is or what homicide detectives are telling him. And they're giving him information. They tell him, it was your father's gun. It was left on the kitchen counter. There's a note down there. A normal reaction to that would have been, well, what did the note say? What do you mean it was my dad's gun? What happened? But you don't hear any of those things because he has no concerns about what happened that night. And I know what all of you are thinking as you sit here. You're thinking the same thing I thought when I got this case. And that's that he doesn't look like a killer. He doesn't sound like a killer. But remember when John talked to you in jury selection and we talked about how there's no definition for what a killer looks like. Because what you know now is that the only person in the world who was handling the weapon and test firing it right before his parents were killed by that same gun is the defendant. In an absence of motive, which we don't have to prove to you, there is something else this case shows us that is powerful. And it's also something we don't have to prove to you, but it's a legal concept you will be very familiar with. Premeditation. There's premeditation in this case. This defendant, especially at a young age, is extremely deceptive. And his mother had started to figure him out. And let me give you a couple examples from the evidence that you can probably relate to. Remember when he was talking about his dad's gun? He was on the phone with a 911 operator, not homicide detectives. He's on the phone with 911 dispatch, and he's saying a rhetorical thing in the phone, which is, where does my dad keep his gun? And then you found out that was a complete lie, because he knew exactly where his dad kept the gun, because he was the one who was using the gun. And then remember the fire that he started in the house? This is where it gets a little weird, because what he told you in his statement was, I was playing with matches, I accidentally dropped it on the floor, it caused that mark, and I put it out, had a talk with Dad, and everything was good. And if you logically think how this would have played out in real time, I want to make sure I understand this. So he takes a match right near the only stairwell to the first floor, he strikes the match, he drops it, and then walks away and comes back later and says, oh, the floor's on fire? Regardless of what his rationale was or how he explained it, you know he lied about that. Because the truth is that he had a bottle of rubbing alcohol mixed with gasoline up in his room. And then he poured gasoline across the floor and he tried to light the house on fire. And then you heard on the night in question, he had all these text messages with Kate. Remember his girlfriend Kate? And there's like 45 minutes around 10 o'clock that night where he is talking about sticking up for his girlfriend, and this boy named Blake spread a rumor, and he even tells her, I'm going to go downstairs and talk to my dad about it, how I should approach the situation, because I don't want to do something that I would regret. And then we found out from his phone records that that was a complete lie. He made the whole thing up. He had a text message conversation with himself that he then forwarded to his girlfriend and tried to pass on like he had actually had a legitimate conversation with somebody. Are you starting to see how deceptive and how his mind works? And going back to the fire, do you remember who he blamed for that fire? He blamed his sister. Just like in the text messages with his mom, he blames Kate for getting him in trouble. Just like he blames his brother for killing his parents. Is there anybody that he's not willing to throw under the bus in order to protect himself? I want to talk about Josh. First, off the bat, you should know that nobody in that family ever went to the police and said, you need to look at Josh. Something's up with Josh. Never said that. All they had to say were good things about Josh. And so now we're in court at trial, and all of a sudden, all this stuff about being the black sheep of the family, and it wasn't his biological father, you hear all this stuff. And I want to let you know, that's the first we're hearing about all this stuff, is in front of you.
Objection. That's an improper jury argument. It's outside the scope of the record, and it's not true.
No sidebar, that's sustained.
Ask the jury to disregard a statement of the prosecutor.
Ladies and gentlemen, disregard the last statement made by the prosecutor.
Move for a mistrial.
That's tonight.
And ask the court to instruct the prosecutor to stay within the record.
Please stay within the record.
Yes, Your Honor. So then they take all of Josh's records, and then they take a psychotic patient's records, medical records, and say, oh, this is what he actually meant by this stuff, right? They say, oh, see where it says he experienced the death of his parents? What that means is that he must have been in the room when this happened. And then from that, what we should get from that is that means he must have pulled the trigger. I mean, what kind of desperate Hail Mary attempt is this? They have totally missed the mark in understanding mental illness and how it played in this case. You want to know the truth about Josh? Here's the truth. Josh may have showed very early signs of schizophrenia around the time his parents were murdered. But all the stuff that they want to scare you with about him being psychotic and thinking he was God and all this other stuff, that didn't come until years later. And if you look at the records early on, before he developed that type of psychotic disorder, where he was just paranoid and depressed, he was doing things like making lists of the people who could have killed his parents. You don't make lists of people who killed your parents if you were the killer. The forensic psychiatrist in this case told you that whenever somebody has signs of schizophrenia, there's normally an event that will trigger it into full-blown psychosis. And that event in this case for Josh Armstrong was his parents' death. And I don't know if we're just not reading the same records or what, but the records clearly tell us that that was the worst experience of his life. And he was a shell of himself because of his parents' death. And you know what? When his brother called Josh to the scene, and Josh went out there solely because the defendant called him to come out there, he never felt more alone in the world than in that moment. His brother is being transported downtown talking with homicide. His sister is in the backseat of a patrol car being comforted by her grandmother. And he is sitting out there knowing that everything he loved was in that house. And he is trying to pick up the pieces and put together what happened. And if any of you have ever experienced something so traumatic in your life, like losing somebody that you loved, and it took you to a dark place, and in that dark place you became unrecognizable to yourself and the people around you, I want you to think of Josh Armstrong. Before he was psychotic in 2018, there's something that Josh said in his December 2016 records from Bentov. It's on page 30. This is in evidence. And the reason I wanted to share this with you, is because one of the things the defense attorney told you in opening was Antonio Sr. wasn't Josh's biological father, and that made him really angry. He didn't tell you the full quote, though. So I'm going to paint the full picture for you. What he said was, patient becomes tearful when explaining that at 13 years old, his mother told him his father was not his biological dad. Explains feelings of anger, followed by understanding and appreciation for the man he knows as his father. Describes feelings of guilt because he feels he is not able to be there for his siblings the way his father was there for all of them. That's from Josh. As this trial comes to a close, I can't help but wonder what Don Armstrong would think of what's going on in this courtroom. To see brother pit against brother, blood against blood. And because they've made it a Josh versus AJ battle, you should know something that's very important in this case that came from the forensic psychiatrist. What he told you on Friday was the person who committed these murders was not somebody suffering from a psychotic episode. It was somebody who had well planned out thought, somebody who took elaborate attempts to go unnoticed by law enforcement, and who was trying to throw the police off their tail. In other words, somebody who was deceptive. And the only person in that household who fits that profile is sitting right there. It's been an honor to try this case in front of you all. John and I, we have a lot of pride standing up here, fighting for justice for Antonio, Dawn, and Josh. We would ask that you be their voice today.
All right, defense, you may proceed. You may.
Well, proceed, Your Honor.
You may proceed.
Thank you, Your Honor. Ladies and gentlemen, three questions to ask yourself right out of the box. Where did the evidence go? Where did the evidence go of the murders that occurred in the house that night? The second question to ask yourself is, can you rely on the accuracy of the state's alarm story? Because it's a story. That's all it is. The state has a job to do. I get it. I understand. But they have to create a story and try to get you to believe their story of what happened. And then last, after you've looked and figured out where did the evidence go, can you rely on the accuracy of the alarm story, then you have to ask yourself, are you left with reasonable doubt? If we look at the state's story about the alarm system, the house is sealed. No way in, no way out. The alarm is set. The alarm had to be turned off. No signs of forced entry, right? So that's the state story. So if the house is sealed, everything you could possibly imagine that goes along with killing Dawn and Antonio has to be where? Inside the house. So where is it? Where's the gunshot residue? Where is the DNA? Where is the blood spatter? Where is the clothes? Bloody clothes, shoes. This house has to have contained anything and everything, all physical evidence that the murders occurred, because obviously nothing could get out of the house, right? The police came, they sealed it, they took over, they had control of everything. And yet not one thing. I mean, where are the wet towels, the wet sinks, the wet showers, anything that would show that somebody cleaned themselves off or tried to hide evidence? It's not there. There is not any evidence at all that points to AJ. It doesn't exist. The state failed to put it on because it's not there. So that leaves two explanations. It's magical evidence and it just vanished. Or the more logical explanation is that it walked out the door with the killer. But because the state, the police, didn't want to look, they didn't even want to interview the next door neighbor, we'll never know where the evidence went. Let's talk about the alarm system. Remember Mr. ADT, Rockstar Engineer? They flew in from Florida. He was here on behalf of ADT, and he was adamant that the alarm records, I bet he'd been willing to bet his life on them. They were 100% correct, infallible, no mistakes at all in those alarm records. You could bank on the accuracy of that information. That was his testimony. I got him to come down and say, are you sure about this? Are you sure that this is what you want to say? Oh yeah, that's definitely it. These alarm records, they're gold. He testified that ADT waited 6 years to finally decide to even go try to look at the alarm system. And ADT's been in this case for 6 years. And they just now waited till a few weeks before this trial to try to go look at the alarm system. When they do go look at the alarm system, what's there? Not the alarm. The panels are gone. He can't test them. He didn't know how anything worked. He couldn't test the motion sensors. No tests were done at all. As he sat here, he told you, I can't give you what the measurements were for the motion sensors. I don't know what they were set at. He goes, well, I generally know what the parameters are, but he can't tell you what the motion sensors in the Armstrong's house, especially in July of 2016, were set at. He couldn't tell you if there was an auto bypass feature even programmed into the alarm system when it was installed. He can't tell you anything about the Armstrong's alarm system. All he can tell you is that the records are 100% accurate. So that was the basis of his testimony. He didn't have anything else to rely on. All he had to rely on was the accuracy of the alarm records. One of the, profound statements that he made was that there was no way anybody could get upstairs without the downstairs alarm motion detector being tripped. Remember that? Remember how adamant he was when the state questioned him? There's no way you can get upstairs without the downstairs motion sensor being tripped. I spent exhaustive accounting from July of 2016 alone of over 77 instances where somebody comes and goes in and out of the house and the downstairs motion sensor never even goes off. There were numerous times I've also counted and went through where the motion sensors alone would either be double idle were double active, which means nothing occurred ever in between them to reset them. I don't have it up, but hopefully you'll remember when I was sitting there going through the thing with the expert, and he said, no, something has to be there in between for them to go from idle back to idle. But the records show otherwise. We know what this is. This is a garbage can. The alarm records are that. Garbage. They are garbage. How many errors, how many mistakes, how many false reportings do you have to have for when somebody says, these are 100% accurate? These you can rely on. As a matter of fact, I believe the state used the term junk in, junk out. Y'all remember that? Well, that's what this is. Junk in, and they rely heavily on this, junk out. The information that you get, you can't rely on. You can't rely if this is accurate or not. We don't know if it's reported properly or not. We have no idea what's missing, what's added, what's duplicated. We have no idea. I'm going to give you an example. On Exhibit 220, on 210 and 222, I believe, right? 221. On Exhibits 221, here's an example of a door where the front and garage door, there's a separate entry of it being closed and a separate entry of it being open. And will you please look at that timestamp? How in the world can you have a door that is both separately opened and separately closed at identical times? Down to the second. This is garbage. This is garbage. Let me show you another example. This goes to the exhibits themselves. On Exhibit 221 and 210, or is it 222 and 210?
210, 221.
Okay, on Exhibits 210 and 221, they cover overlapping time periods, okay? When they do this, here's an example on the bottom of a front and garage door that's open and closed at 7:28. The timestamp is 9:38:46. If we compare that to the exhibit, which is underneath it, for that same exact time period, where is that entry? It's missing. The exhibits don't even match up. They are missing their own records. This is how ridiculous these alarm records are. Tim Rader, the ADT guy, he says, the Armstrong's alarm system is subject to compromise. He agreed. And it's subject to compromise by an intruder. An intruder can access through a bypass opening. In this particular case, the state wants you to believe that these records are solid.
Objection, Your Honor, this is in evidence.
Huh?
This sheet isn't in evidence, is it?
No,
You said is or is not?
I don't believe it is with the writing on it.
not with the writing. It's the example of the.
Could you speak up so I can hear you?
Yeah, I'm sorry, Your
Could you
Honor.
clarify?
Yes, it is from evidence, and all I did was take the part of it and cross it out. But I'd already showed you
Just a minute, no speaking
Oh, I'm
objections,
sorry.
sorry about that. Mr. Jordan, do you want to
As
review?
long as he makes it clear that it's not in evidence, that document, that's been written.
Yeah, yeah.
All right, please proceed.
Yes, Your Honor. Go ahead and put it back up. These are both sheets taken from Exhibit 210. So I could help direct your attention out of all the different line items. I, on the top, boxed off the section that pertains to the night in question, where it starts with the alarm being armed to the time that the alarm was disarmed. That's about all that we really know in this case. Underneath it, the part from the alarm being armed to the part being disarmed is the part that I sectioned off out of that because we can't rely on that information. We can't rely, based on the records alone, we can't rely as to what happened. And yes, that is, the drawing part is not in evidence. The documents are, the alarm records are. So, if we were to sit, you can go back and put that back up. If we were to sit and really look at what's in evidence, this top part right here, and we were to follow what the motion detectors did and all of that, then you would have to equally believe this scenario. You'd have to equally believe that somebody came in through the front door, that they came upstairs, because right now what we have, and this is going backwards, so everything in order goes from this and goes up like that. So we have the thing being set, both upstairs and downstairs detectors go idle, then the upstairs gets activated. So we know that somebody could come in. Clearly, they can go upstairs without being detected. They get to the top of the stairs, and then the upstairs motion detector picks them up at the top of the stairs. We know that Antonio and Don are killed. We know that the killer runs downstairs. And then as he runs downstairs, and on his way to the kitchen, the living room motion detector picks him up. He goes to the kitchen, he leaves the gun, he leaves a note. Matter of fact, from the time the living room motion detector, according to these records, picks him up at 1:25 until the alarm is turned off at 1:56, that gives 31 minutes for that killer to have gone into the kitchen, left the gun, write a note, and escape. 31 minutes. That's a lot of time. So, what story do you believe? Because it's a story. You can't rely on the accuracy of the alarm records. That's clearly established. But the alternative version that I just painted you is actually supported by the alarm records. If somebody comes in the house, it doesn't get picked up by the downstairs motion detector. Kara told you that everybody used the big garage door to go in and out of the house. That's how everybody just entered and exited the house on a day-to-day basis. They always left the door that goes into the house from the garage unlocked. She said they always had problems with it staying open, that it would pop open. She said that she could set the alarm, and I found this interesting. She could set the alarm by both the panel, where you have to push the buttons, and by a key fob, with the downstairs garage door being popped open. Now, the state would want you to believe oh, well, you have to go actively do something to force some sort of a bypass because something's going to pop up and keep you from doing it. But that clearly can't be the case if you're setting it just with a button on a key fob. The point of all of this comes right back to, I'll put the original one back up. Comes right back up to the last question you had to ask yourself. Does this create reasonable doubt? Does this leave you with reasonable doubt? Where did the evidence go? Can you rely on the state's concocted, made-up story of what occurred? Because clearly they weren't in the house that night. We can't rely on the alarm records to tell you what accurately occurred. We don't know what accurately got reported, got left out, anything along those lines. So does this leave you with reasonable doubt? Ladies and gentlemen, AJ deserves to have his future decided on something more than records that are garbage. Let me take these up before they fall in.
Chris.
There. We've all worked hard in this case. We know you have worked hard paying attention in this case, seen you diligently taking notes. We greatly appreciate your time, your attention, your effort that you've put into this case. But at the end of the day, there is reasonable doubt all over this thing. And I'm working on limited time. You'll hear more from Rick in a little bit. But just on the alarm system alone, just trying to figure out where in the world did this evidence go? I mean, is AJ at the age of 16 some professional trained assassin who somehow knows how to put all of this together to get away scot-free because there's no evidence that points to him? I don't think so. It don't work like that. So at the end of the day, after you've considered it all, we ask that you please return a verdict of not guilty and set AJ free and do the right thing. Thank you.
Sure, and that was 21 minutes. Okay. Sure.
May I proceed, Your Honor?
You may.
Ladies and gentlemen of the jury, to the Armstrongs, thank you. Thank you for your trust. Thank you for allowing me to fight for this young man. Ladies and gentlemen, when we started this case, we talked about the state's burden. Yeah, I brought it again. It's heavy. State's burden. Before we put a young man behind those doors for the rest of his life, that's the burden. And I told you to think about Mr. Trask and Mr. Jordan walking around this courtroom with that on their backs, because that's what they have to carry. It's a high burden. And I agree with Chris. This case and everything you filter in this case is about reasonable doubt. Do you have a doubt? Are you sure? Talked about it earlier. You're going to be home the next day drinking coffee and say, man, I'm not sure about this. Everything you filter in this case is about reasonable doubt. Now I'm going to give you a hypothetical. Let's assume that Tim Rader is a doctor. And someone goes to Dr. Rader, the ADT guy, and says, doctor, I have this pain in my back. The doctor does tests. He has you meet with other people. And the day comes and Dr. Rader calls you and says, come on in. I need to talk to you. You have a cancer mass on your spine. If you don't have surgery, you're going to die. If you do have surgery, you could be paralyzed for the rest of your life. I think we'd all agree that that's a serious decision, much like deciding life in prison. And you say, doctor, thank you. I'm devastated by this. I'm going to get a second opinion. And you get all of Dr. Rader's tests and everything he did, and you take it to another doctor. The doctor says, let me get back to you. I'm going to review these. The doctor calls you back and says, sir or ma'am, I've looked through all these records, and there's at least 77 errors in those records. I've also found out that Dr. Rader State failed to talk to anybody that you talked to about food poisoning. There's some notes in here that say you could have food poisoning. We need to look at it. They should ask the patient what he had to eat, what he or she had to drink. But Dr. Rader ignored that. And the second doctor says, look, I just think you had a case of food poisoning. And let me show you all the errors in his records. How many people in here would have that surgery? Raise your hand. Raise your hand. Prosecutors, court staff, how many people in here would have that surgery? Why? Sergeant Dagnall didn't even raise his hand. He's sitting right there. Why would you not have that surgery? Because you have a reasonable doubt about what that doctor did. Dr. Rader. That's an example of reasonable doubt. And it's displayed in front of you. Number two, the prosecutor said the family never went to HPD to talk about Josh. You think HPD would even listen? Do you think HPD would even care? They did nothing in this case to investigate Josh. And we'll talk about that in detail. But let me give you another hypothetical. Tim Rader said, not Tim Rader, the state's mental health expert talked about attribution. We'll talk about that too in a minute, but let's attribute what we know about Josh to AJ. Let's say, hypothetically, AJ got into an angry fight with his parents, he was upset, and his parents cut him off. What would they be saying? That's motive. 2 weeks before his parents were killed, AJ got into a fight with his parents, was upset, and was cut off. That's what we know about Josh. They would be standing up here like I am saying, that's motive for AJ. Let's say AJ spoke with someone and they wrote down those notes and AJ told that person he witnessed his parents murdered. These two gentlemen would be falling over themselves to get in front of you to tell you, this is a confession. He witnessed his parents murder. If we attribute that to AJ, but we know Josh said it. When Josh says it, it's not what it means. We have to attribute it to somebody. It could mean this, it could mean that. AJ said it. They'd have it on a big board all over this courthouse. Let's say, hypothetically, and attribute what happened with Josh's girlfriend. Let's say AJ's girlfriend said, hey, HPD, he was with Trenton Teamer that night. How quickly would Dagnall and his two buddies have tried to find Trenton Teamer to confirm or verify that? How quickly, if that was AJ who said that, would they have gone out and found Trenton? Said, is this true or is this not true? There would be skid marks in the street from the HPD cruiser. And if Trenton Teamer told them he wasn't with me, they would be standing on this table like I was that day saying, he doesn't have an alibi. Why doesn't any of that apply to Josh? Why doesn't it apply to him? It only applies to AJ if those circumstances happen? It appears that Josh had a motive. They never interviewed Trenton, and we'll get into this in detail. Why doesn't it apply to Josh? Why are they minimizing everything that Josh did or said? They have to. They can't get around it. Thank you for your patience. Thank you for always being here on time. Thank you for tolerating the constant may we approach and these things, the headphones, how much time we wasted with those. Thank you. We appreciate it and we notice. We picked you guys for a reason. Now let's get into the case. I'll agree with the state that if this was a case about a normal, typical 16-year-old, he's guilty. Yeah, he smoked marijuana. Okay. It's not great, but he smoked marijuana. He lied to his parents. Raise your hand, again, anyone who was 16 and didn't lie to the parents. Even Dagnall didn't raise his hand. Really? He was getting in trouble for spending too much money on his friend. I forgot what the text said. Okay? As a 16-year-old with a girlfriend, he didn't want to spend time with his sister. Okay, he's guilty of that. I can tell you in my family that was common. I'm sure if you have siblings, you know the same. His parents were frustrated with him. Yeah, his mom called him a liar. And sure, he did lie to his parents. And they want to stand up here and tell you that's not motive. But they know there has to be a why. There has to be a why.
Object to misstatement of the law.
All right, ladies and gentlemen, you will have all the law that's applicable in this case. Sustained.
We'll talk about text messages in a little while. But he's guilty of being a 16-year-old. We're not up here to tell you he's a perfect kid. But is the evidence to send this young man behind that door for the rest of his life that he didn't want to spend time with his sister? Or all those other texts? It's just not enough. It goes into reasonable doubt. And let me talk to you quickly about reasonable doubt. Reasonable doubt. It's not one thing. It's as we go through the case. Things add up. And I told you that. There's a string that goes through this case. You can pull it tight, and there's reasonable doubt hooked on it all the way through the case. Sergeant Horelica, first one at the scene. Within 11 minutes, he made up his mind. We told you that at the beginning. Within 11 minutes, he called down on his radio and broadcast to everyone out there, think AJ did it. He was so sure that he thought AJ did it that he broke police policy and let Kayra out of handcuffs and let someone come back in the car. That's where the infection started. That's where the disease started. And that's another string that goes right through the middle of the case. Confirmation bias. It's otherwise known as and you remember this, not pertinent to the investigation. Confirmation bias, not pertinent to the investigation. We asked for those audios, but we know that that spread. And he made up his mind. He said it was a gut feeling. Gut feelings aren't based on evidence. We don't have gut feelings in here when so much is at risk for this young man. We know that at the time there was no gunshot residue, no blood, no fingerprints, no DNA, no nothing. So as that disease spread to the homicide investigators, as it spread to everyone out there, it started to shape how they looked at the case. They made up their mind as to what was going to happen. And they made the decision, and we'll talk about that, of what not to look at. Now, the prosecutors usually say the defense attacks the police when they have nothing else. They didn't do their job because they made up their mind. And I think the evidence is credible and legitimate as to that. But that was an example of how the disease of not pertinent to the investigation started. In AJ's statement, he tells everybody, you can test my hands, you can test my clothes, you can test whatever you want. There's not going to be any evidence on me. How in the world would a 16-year-old know that? Are there any searches on his computer that they showed you that how to avoid forensic evidence? And jail's going to be putting the photographs up. How in the world would he know that? The officers even said he lied to him about GSR, and if you shot a gun, you're going to know we're going to find it. He didn't know what that meant, really. He just said it's not going to be on me. And he was right. He was right. There's no evidence, physical evidence. As we go through this, as we weave through the case, think about the credibility of the witnesses and what they have to say. Now we're going to stop and move to the physical evidence. Let's talk about the gunshot residue. Get the other gun. Deputy, can you please check the weapon? All clear. Thank you, ma'am. GSR, gunshot residue. If you shoot a weapon, there's a probability that there's going to be gunshot residue on your hands, gunshot residue on your jacket, coat, could be on your face, could be on your hair, could be anywhere. Let's talk about credibility of witnesses. The state was trying really hard with Mr. Schroeder to get you to believe that 22s don't have the 3 elements for gunshot residue. And the third one being antimony. Nope, in my whole career I've never seen gunshot residue on a 22. Nope, never happened. It's not possible. It's worthless. Well, we know the detectives thought it was of some value out there because they bagged their hands. But they got into this stuff about how there's no way there's going to be residue from a 22, so whether or not they have gun residue is not relevant. But then on cross-examination, we find out, sir, what's the third element that's not in blazer ammo? Antimony. Well, when you looked on their webpage, did you see what percentage of antimony was in that bullet? Yeah, 5%. So there is the third element in here. That's inconsistent with his direct examination. They tell you it's 100%. 100% accurate, the alarm records. There's no antimony in here. It won't show gunshot residue. The last question he was asked on cross was about the antimony. They did not redirect him. They did not ask follow-up questions to that. That evidence comes in uncontroverted. So what do we now know? It's not that there's not going to be any gunshot residue from a .22. It's that it's possible that it could be there. Joe, can you put up his clothes, please? But we do know that it's not anywhere in the house. They didn't find it anywhere. And AJ shot a weapon in a closed environment outside. No blood anywhere. None. No blood on his clothes, on his hands, on his face, in his hair. Nowhere. Shoes, pants, nowhere in his room, except in that bedroom. None. You had the opportunity to see those those photographs. They're not great of the room, but there's a lot of blood there. No blood anywhere. No fingerprints. No fingerprints on the weapon. No fingerprint in the room. No fingerprint anywhere. Nothing. No fingerprints. DNA. That nice lady came in and talked about the DNA, and it was probably the most confusing thing I've heard in a long time. It was so confusing that the prosecutors decided to say, just look, it doesn't really mean anything. It means nothing. And I asked her, what does it mean? And she's like, it doesn't really mean anything. No DNA. On the weapon, on the bullets, on anything to indicate that AJ was involved in this. No physical evidence. That ties up with Chris's theory that the physical evidence left the location. Crime scene is compromised. 8 or 9 people came into that crime scene. They're pulling off pillows. They're moving stuff around. They're putting pillows in blood. I get it. I get it. You're trying to save lives. But that crime scene is compromised. Nothing that had come out of there they can say anything about. We'll talk about that in a second. But we don't know where anything was. There's one thing we do know, and I'm going to talk about that in a second. That crime scene was compromised. All right, Jimmy James. Jimmy James is the crime scene unit investigator. Mr. James is the perfect example of it's not pertinent to the investigation. Mr. James is the perfect example of confirmation bias. He had an idea of what happened in this case, and that's all he looked for. We asked him, hey, on direct or on cross, did you go into the garage? Yep, I peeked in the garage and I looked in and I looked around. Well, hold up now. You testified previously that all you did was open the door and look in. Is that a lie? I don't know, but he testified differently in 2 separate hearings under oath. There's something else I'll remind you about in a minute. Could there have been something in the garage? Yeah. Or in the attic? Yeah. No, we talked about the garage, same issue. You didn't look through the garage. I asked him, Jimmy James, did you find the sensor in the emergency bathroom? Remember that? He said, I don't know. No. What is an emergency bathroom? I mean, to be honest with you, I just made that up. And he had no idea what that was. Think about the arrogance of that. Think about what Jimmy James had to be thinking before he walked into this courtroom. I'm going to tell you how it relates to confirmation bias and how they think about things. He came into this courtroom saying, the evidence is against AJ, and that's all it is. And I'm not going to agree that anyone else did it. I'm not going to talk about it, anything that I missed. I'm not even going to prepare for trial. As citizens of Harris County, you should be frightened of Jimmy James. Because this young man could go to prison for the rest of his life. And Jimmy James,
Improper argument.
Sustained.
and Jimmy James didn't have the courtesy, the courage to prepare for this case. Because he didn't even have any idea what was in the emergency bag. It doesn't even exist. That's how bad his testimony is. That's reasonable doubt. The guy who collected the evidence and was in charge of looking at it, that's reasonable doubt. And if you remember one thing from this part of it, it's not pertinent to the investigation. Remember that. He didn't know anything about the alarm system. Nothing. He didn't take any pictures the night he was there. So their theory is the space is closed. It has to be AJ, no one can get in and out. The crime scene unit investigator had no idea that there was an alarm system there. He didn't even take photographs. None. He had no idea about the keypad outside the garage door. It's not pertinent to the investigation. Hey, Mr. James, is it possible that someone could come in through that keypad and get in the house? It's not pertinent to the investigation. Did you check to see if there was any fingerprints on that keypad? It's not pertinent to the investigation. Did you take any DNA? It's not pertinent to the investigation. Did you check the garage for blood? I could just hold up a sign now. It's not pertinent to the investigation. Did you check the inner door for fingerprints or DNA or anything? It's not pertinent to the investigation. Really? He testified that they went back the next day and tested the alarm system. But all they did was open a couple windows and see if it beeped. And that's dangerous. In a trial of this magnitude, to use the word tested, it's in the details. They did not test that alarm system. They opened a few windows, and that includes Dagnall and his homicide buddies. They just opened a few windows to see if it beeped. Is that testing to make sure it's accurate? For them to come forward and say it's accurate, it's 100% accurate? No. It's scary. Text messages, please go through them. Please spend time back there going through them and see what was going on with the relationship with AJ and his parents. Yeah, there's some stuff in there where his mom calls him a liar and he's getting in trouble, but he's also talking about his grades and telling his mom his grades. And there's one that says, hey, beautiful parents. But the thing that's most telling is yes, sir, no, sir. Yes, ma'am, no, ma'am. Throughout all those texts, when his mom and dad are getting on him about all the stuff that's going on, does he ever get angry with them? Does he ever say, nah, Mom, this is BS. I'm going to do what I want. This is unfair. You guys are treating me unfairly. I'm not going to get grounded. No. That's so telling about this young man. Yes, sir. No, sir. Not a perfect kid. Those text messages are the banter of a 16-year-old and his parents who's getting in trouble. He had a Mustang and he drove fast. How many 16-year-old boys had a fast car and drove fast? I know Dagnall probably did. Come on, really? When we talk about demeanor, and the charge talks about the relationship with the parties, talks about the relationship with the parties, and that's AJ and his dad. And AJ and his mom. That yes sir and no sir goes a long way. The most telling evidence in this case, and it talks about it in the charges, what was his state of mind at or around the time of the offense? What was his state of mind before this happened around 1-10 in the morning, whenever they think it is? I said it before and I'll say it again, and my wife made fun of me, but he was having kissy faces with his girlfriend. He's texting his girlfriend, I love you, I miss you. Will you marry me? Yes. That's where his mind is. He's a 16-year-old in puppy love sending goofy messages to the girl he's in love with. Is that the state of mind of a killer that's going to execute his parents 90 minutes later? Does that make any sense to you? Is there anything that night that indicates to you that he has the mind frame to execute his parents? So let's get this right. Whoever did this executed those people. They had to have some type of rage in them, some type of anger, maybe a demon in their head. But is he going to go from, I love you, babe, I can't wait to marry you, I want to be kissing you, and then a very short time later, execute his parents? That makes no sense whatsoever. That is reasonable doubt, as clear as it can be. It's flashing at you. Okay. So let me understand this from the state's perspective, and I kind of got to spell it out loud so I can get through it. You're telling me that AJ is a deceptive, lying murderer because he faked a text message to impress his girlfriend. He faked a text message to impress his girlfriend. How can you make that leap? They had Nathan Gates create their own little demonstration. This is how he faked the text. Okay, so what? Now, if he went over to Blake's house and knocked on his door, Blake, let's fight. You said something very disparaging about my girlfriend, and I'm going to kick your ass. Let's go. Come on. Get out here, Blake. And then they got in a fight. That's consistent with someone being violent and angry, and I could see their position. But he did the non-violent thing. And he was trying to impress his girlfriend because he's a goofy 16-year-old. He didn't want the confrontation. Maybe he was scared of Blake, I don't know. But he faked a text to tell his girlfriend, I defended your honor. Because we know Blake was talking bad about some type of sexual act with his girlfriend. And as a 16-year-old, that could probably make you crazy. He was defending his girlfriend's honor in a nonviolent way. But their position is, oh, he's a killer. He's deceptive. Come on. Thank you, Judge. A lot of text messages here, and I'm gonna let you in on a lawyer's secret, like a pro tip, okay? If the prosecutors get up here and tell you Mr. DeToto has subpoena power, and he could have gotten any records he wanted, number one, that's them transferring the burden to us, which they shouldn't do. But number two, it's them telling you they don't want you to know what's in those records. We have no burden. None. We don't have to bring anything to you. We're not required to. Under the law, we are absolutely not required to bring any evidence to you. We're not required to go out and get it. We're not required to prove to you who did this. It's their burden. And if they tell you Mr. DeToto had subpoena power, it's very telling. And I say that to say this. Where are Josh's cell phone records? State of Texas. Where are Josh's cell phone records? You've had 2,264 days. 2,264 days to investigate this case fully. Look at him and ask him, where are Josh's cell phone records? When they stand up there and argue in front of you like I am, ask him, where are Josh's cell phone records? They didn't bother to get them because they don't care. And they don't want you to know what's in them. 2,264 days to interview Trenton Teamer. Why is that so important in this case, and why does it show exactly what I'm talking about? Hannah tells you, hey, Josh is at my house. And I fell asleep between 10 and 11, and I went to bed at about, Josh woke me up around 2-ish. But Trenton Teamer was there. I don't remember if it was Dagnall or the other homicide officers. Yeah, we knew about Trenton Teamer. In fact, it was written in their notes. Now, let me tell you this. If we attributed that to AJ, I know that didn't make sense. If we attributed that to AJ, when I did the hypothetical, if his girlfriend said he was with Trenton Teamer, they would be falling over themselves to interview Trenton. Mr. DeToto has subpoena power. He could call him in here. It's not my burden. They did nothing to determine whether or not Josh had an alibi. Because if they interview Trenton Teamer in the past 2,264 days, he's either with him or he's not. They don't want you to know. And I'm not saying them, I'm saying the Houston Police Department. And I'll say it again, if AJ said that in the reverse situation, they would have talked to him. Grand jury subpoena, investigators. This is the third or fourth biggest police department in the United States of America. They have more investigators than they know what to do with. They don't want you to know what he has to say. Or they don't care. Or they're incompetent. Either way, it's a reasonable doubt. Talk about the test fire. Prosecutor brought it up. So I'm running out of time, Judge, now, please. Test fire, prosecutor brought it up. AJ, they're saying he test fired the gun. The biggest point on all that is, Joe, can you put the photograph of the picture through the roof? Please, man. Remember how they talked about the drywall that was on the floor? And when they walked in the house, they saw the drywall, and that's how they could tell that it happened recently. They're trying to infer to you that it happened that night. Right? Y'all remember that? Where's the drywall? Where's the drywall? On the floor. That's the only thing they have to say that it happened close to the offense. Where's the drywall on the floor? State of Texas. Officer Dagnall, as you sit there, you took no photographs of it because you admitted on the stand that there's no photographs of it. They didn't show you any photographs. Perelica says he never saw it. Jimmy James never collected it. That's an assumption by them because it fits neatly into their theory. AJ said it was done before with some friends. There's no drywall. But they talk about it to make it sound like it happened that night or close to that night. It's reasonable doubt. Number two, why not find out who the friends are? Officer Dagnall is in there interviewing AJ and AJ's answering him. Why not find out who the friends are? Is it Trenton? Who could it be? Find out. Go look, ask, confirm or deny. Don't just not investigate and come in here in a capital murder case and accuse him of something that you never verified or denied. That's dangerous. That's how innocent people go to prison. Those are the details. The devil's in the details. I guess you could say it's not pertinent to the investigation. Okay, we gotta talk about Josh. We are not trying to stigmatize Josh. I feel sorry for that young man. We all do. The allegation by the DAs that we're picking on him because he has mental illness, no way. I can tell you this family, if I become as close as my own family, would not allow us to do that. To just pull something out of the air to say, Josh is mentally ill. Let's just throw it out there and see what happens. No way. I have too much respect for you, and I have too much respect for that family to do it. We have legitimate, credible information about Josh that we believe is relevant to your determination of of beyond a reasonable doubt. I think you can agree with me that it's credible and reliable and relevant information in this case. We're not just singling him out because he has mental illness. We want you to hear the whole story. Do you think if they presented this case and me, Jal, and Chris stood back here and played crosswords and really didn't pay attention, do you think that they would have given you all the information about Josh? Do you think that would have been fair and impartial in this young man's life and said, look, there's evidence here and there's evidence here. We're going to let you decide? No, they wouldn't have. And you would have gone home the next day and maybe learned on the news or wherever all this information about Josh. And you'd have been like, wait a minute, what is all this? It's credible, reliable, relevant information about Josh. What do we know about Josh? He left Glenn and came to Houston. He lived upstairs in the room with AJ, so they shared that upstairs room. Clothes and stuff are mixed together. There's some evidence that Josh's iPad was up there. When Josh came back, he was not himself. His hygiene was bad, he was disheveled, smoking marijuana and drinking alcohol. Here's something that kind of went under the radar and I want to talk to you about it. Kayra said he's in the bathroom talking to himself for hours. And it's like he had a voice in his head. Their own expert told you and tried to make it a spectrum, said that at the end of the spectrum, when someone has full-blown psychosis, they have auditory hallucinations. They have voices in their head that they're talking to. That evidence from Kayra takes you all the way back to before this happened. And according to their own expert, he's having auditory hallucinations, and it's an advanced stage of psychosis. The other thing you got to think about is that he was never taken to the doctor before then. There's no medical records. It's only after. So we can't speculate as to what the doctor would have said before. But there's no question that he was having mental health issues prior to the murders. None. And according to their own expert, he's having auditory hallucinations. I think Kayra said he had a demon in his head. He had a fight with his parents, yelling and screaming. They were cutting him off, and they were kicking him out. That's motive. That's motive for Josh. If it applies to AJ in that circumstance, it applies to Josh. So we have someone who is having auditory hallucinations, a demon in his head. His parents have just kicked him out, and they're cutting him off. He was angry. He was yelling. He had complete access to that house. Complete. He lived there. He knew the code. He could get in the doors. He had complete access. We know that, can you show the kids at the gun range? We know that he fired the gun before. Senior, little Kayra, little AJ, and Josh. All this evidence is credible. Can you grab the medical record? And just park this tab, just put it up. Now let's talk about records. And there's a lot of medical records in the case, and a lot of talk about it. It's interesting that when the state's records come in, they're 100% accurate. 100% accurate. They don't lie. They always tell the truth. You can take it home with you. We learned that that's not true, as Chris described to you. But when we bring in medical records, their expert says you have to attribute it to somebody. There has to be attribution. We don't know if this is what Josh really said and who he said it to. Those records come in as they are. There is no controversy about those records. That is mere speculation. Mr. Collins got their witness to admit there's problems with these records. There's at least 100 errors, and the alarm can be breached. That was not done for those records. It's pure speculation. Witnessed the murder of his parents. That is too much for them to handle. It creates an enormous amount of reasonable doubt. So what's the next thing they have to do? Well, we don't know who told it to the doctor. It could have been a nurse who misunderstood Josh. We don't know what it means. We have to attribute it. That's pure speculation. Get the doctor down here. The person who wrote that note, get him down here and have him explain it. They didn't do that. Those records are as they are. I lost my notes. Homicidal ideations. Would not talk about it. Angry. You can go through those records. This is throughout it. Auditory hallucinations. A woman in his head he wanted to kill. Thought he was God. Multiple times. Witnessed or observed his parents being killed. Go through those records and look at it. They come in without controversy. And as far as you know, for purposes of this trial, they are what they are. When he says he witnessed his parents being murdered, that's what it means. Whatever they want to argue, it's pure speculation. Maybe it was one of the demons in his head who witnessed the murders. And he's expressing it. We don't know. But all of that is pure speculation. We talked about Josh as a motive. I want to talk about emotion, and I'm going to give you another lawyer tip. When the evidence is against you, and there's a lot of reasonable doubt in the case, use emotion. It's a pro tip. When the evidence is against you, and there's a lot of reasonable doubt, stir up the jury with emotion. Try to get them emotional so they look past all that. I've known these two lawyers for a long time. Mr. Jordan's going to get up here and talk to you, and I predict he's going to try to make you get emotional. It's not about emotions. It's about, did they prove their case? And it's about reasonable doubt. Emotion doesn't come over reasonable doubt, overcome reasonable doubt. It doesn't overcome credible evidence. It doesn't overcome anything. You heard from some coaches about AJ's demeanor. Got along with his parents. No issues, no violence, no nothing. Heard from Kayla. Chris, JL, and I have carried this case with us for 6 years, and it's kind of hard for me to believe that I'm standing in front of you right now. Because we've fought, we've cried, we've had ups and we've had downs. We've worked all night to try to help this young man get justice in this case. We've stood out in front of him every time we walked into this courtroom. Said, you're going to have to come through us and prove this case beyond a reasonable doubt. I'm going to step aside now. As hard as it is for me. We're going to step aside now. We're going to give him to you. He's in your hands. And you have a very serious decision to make. And I'm going to respectfully ask each one of you to give him back to us. To give him back to us. The evidence in this case does not rise to beyond a reasonable doubt. There's too many inconsistencies. There's too many problems with the witnesses and everything that you've heard over and over and over again. Thank you. Last thing I'm going to say before I give AJ to you, we talked about this in jury selection. The 12 of you that sit in this case are an island. Each one of you is an island, and you get to choose what reasonable doubt means to you. And you get to decide on your own if you believe the evidence in this case. Each and every single one of you. That's how the law works. That's what this young man deserves. That's what this whole audience deserves. That's what you deserve. If you don't agree with the decision, stick to your guns. Fight for your belief, no matter what it is. Because we don't want to give in because you get tired or you get frustrated, and I know you want to go home. We don't want to give in to your belief and convict an innocent young man of something he didn't do. And I thank you before, and I'm going to thank you again. I'm going to ask you to fight for this young man. Fight for him, whoever you are. It's really, really hard for me to sit down now because I have to give him to you, and I've been carrying him for 6 years. Give AJ back to us. Give AJ back to his family. Thank you.
All right, ladies and gentlemen, we're going to take about a 15-minute break. Just ring the bell when you're ready to resume. Please retire the jury.
All right, the jury.
I'm going to start where Mr. Tototo ended. Do you remember how he said, the trick of the trade? What lawyers do is talk about emotion when they don't have evidence on their side. Do you all remember that? Maybe that explains why we've been having to look at a picture of the defendant when he was 12 years old with his dad during this trial. You think they're trying to play on your emotion to have you ignore the evidence? See, the suggestion is we're trying someone who's little, who's 12 years old, not capable of murder. They couldn't come up with a better picture of A.J. Armstrong and his dad than on the Pee Wee football field? Who's using emotion to have you ignore the evidence? Then you have had to see this picture of Josh Armstrong on the worst day of his life. The beginning of him spiraling out of control. In front of a police car. Devastated. You think they're trying to send you a message? Imagine if Ryan and I had put up the picture of A.J. Armstrong in front of that police car with handcuffs on and paraded in front of you all week long. Wouldn't you have been offended? Who's playing with your emotions? And who's giving you the evidence? You know, there were 2 victims on July 29th, 2016, but there are 2 more as well. 2 people who now have to live the rest of their lives without their parents because of the defendant's actions. Let us not forget that. Who is the first person A.J. Armstrong decides to call as he exits the house? Does he call his grandparents? Does he call his sister? He calls the person he respects, he trusts. He calls his brother. And his brother quickly grabs the shotgun. Isn't that kind of inconsistent with someone who just murdered their parents? Gets in the Mustang, drives to the scene. But in that phone call, Josh talks to AJ, and listen to what AJ says about that call.
Because when I explained it to my brother, he thought the exact same thing. He thought there's something missing.
Josh's like, what are you talking about? This doesn't make any sense. I want to talk about Josh. There were no signs of mental illness before the murders. Let me say that again. There were no signs to anyone of mental illness before these murders. Police officers talked to all the family members. Not one said one thing about Josh having any kind of mental disorder. You saw medical records that you can stack this high. And as you know, there were 3 to 5 lines from his grandfather who said, I saw it beforehand, but what he describes is a kid going to college, being unkept, smoking pot, right? No signs of mental illness beforehand. It is a fiction. The only thing you heard is from Kara, she was 12 years old, that he locked himself in the bathroom. That could be locking yourself in the bathroom to smoke dope. It could be the beginnings of mental illness. But there's no way they'd gone all the way to psychosis. It is a false narrative to suggest that he moved here in May, was here living with the defendant for months, and then 2 weeks before the murders got kicked out of the house because of some type of conflict. Remember how they've said that? There's no evidence of that. Kara does say there was an argument, but the plan all along was for Josh to move back in July and move into his own apartment. It was already set up. You heard that from Hannah. They moved in. He moved into an apartment on July 6th. That's when the lease began. Kara acknowledged that. That's 3 weeks before the murder. They were setting him up in the apartment. There wasn't this being in there for months and then a conflict. The parents set him up in the apartment. You can actually don't have to trust me about it. You can trust the defendant. Because what does he say?
Now, you have an older brother that doesn't live there?
No, he's not. He just moved. He was going to Berlin, and he just moved back like 3 weeks ago. He's going to the Art Institute now,
Okay.
and he lives in those apartments. Like, our house is here, and when you come out and make that left on Maple Ridge, he lives in those apartment complexes right there.
Okay, so right around the
Yeah, it's
corner.
right around the corner.
Okay,
I
right
work
around
his
the
house.
corner. Now, how is his relationship with everybody in the family?
I mean, he's really, like, me, him, and my dad are, like, a really close group. Like, we sit down and talk a lot. And then him and my mom are, like, identical people. Like, their personalities are the same, so they're close. And then me and him are just, like, have a really close brother relationship. And then my little sister, like, loves him.
So not only does on the night in question, he endorses Josh, doesn't say one bad thing about Josh, says that he gets along well with the family members. Remember how this began? He says he moved back 3 weeks ago.
Now, you have an older brother that doesn't live there?
No, he's not. He just moved. He was going to Berlin, and he just moved back like 3 weeks ago. He's
You
going
see?
to talk.
You see that? He just moved back 3 weeks ago. That was the plan all along. There was never kind of an argument with the parents that got him kicked out of the house. He was always moving then. Not to mention the fact he was given the Mustang. Who gets in trouble with their parents and they take the Mustang away from the defendant and give it to Josh? Further evidence that you know Josh was not on the outs with the parents. Defense counsel says we could have gotten Josh's cell phone records. Actually, we can't. You have to have probable cause to believe they committed a crime to get someone's cell records.
Objection.
That is the law.
Objection. Improper argument. It's not completely accurate.
Overruled.
It's completely accurate. The reason is I can't just come and grab your cell records. I actually have to have probable cause that you believe something. I'll tell you what we do have. We have A.J. Armstrong's cell records. We have Antonio Sr.'s cell records. We have Don's cell records. They have them too because we gave them to them. And there's not one text message from Antonio or Don with Josh that is negative. Not one. You know all the conflicts between A.J. and his parents. There is not one text message that proves their point that Josh was on the outs. This is a fiction. They want you to believe mental illness means murder. Are you offended? Are you offended? You heard from one of the most renowned forensic psychiatrists in the nation, who told you in those small percentage of cases when someone with schizophrenia and psychosis, the types of murders that they do, they believe they are unjustifiably justified. They're bloody scenes. They believe they are doing it for demon purposes. They stay at the scene and say, I did it and I'm justified. This crime scene is the exact opposite of that. Now, we know why the family or folks may want to believe Josh did this without any evidence. See, it's somewhat easier to accept that someone does something because of a mental illness, then you don't have to blame the person that you love. That may be their truth, but it is not the truth. And in this courtroom, the truth prevails. Josh Armstrong is innocent, and his character and his mental illness has been dragged through the mud in this courtroom in order to get this defendant off. I want to talk to you all for a moment. Before I talk to you about the evidence. Seems like a long time ago, about 3 weeks ago, remember when y'all sat out there in another courtroom? It wasn't just y'all. It was a total of 240 people. And here you are. You know, the first questions we get after all these are done is, why me? Why am I sitting here? And I don't know, can y'all look to the side of each other? If y'all looked at each other while this has been going on? Y'all are as diverse as our community itself. We literally have 6 men and 6 women on the jury. Every race in our community. Every age. Some people retired. Some people beginning their careers. Some people who are single, some are married, some have grandkids, some have grown kids, some have 12-year-olds. You are as diverse as the community itself. And let me tell you, don't worry about them. Don't worry about the cameras. Don't worry about people watching. There's a reason why Ryan and I have frustrated the media by not talking outside this courtroom.
Objection. Outside the scope of the record, improper jury argument.
Sustained.
Ask the jury to disregard.
Ladies and gentlemen, disregard the last statement made by the prosecutor.
Move for mistrial.
Denied.
And I will then ask you to instruct both prosecutors to stay within the record and the rules of ethics.
Stay within the record.
It is you who represent the community. You can ignore the outside noise, it doesn't matter. You represent our community. You are empowered with a decision. Now, one of the things we talked about 3 weeks ago in jury selection is there is one thing that we do not have to prove. Do y'all remember that? We spent a lot of time on it, and it's motive. It was the one question I asked every single, all 240 actually. And there are a whole lot of people who said, yeah, I get it, John, you don't have to prove the why, but I need to know. And I know myself, I could not come to a verdict without knowing the why. Remember those folks? They are not sitting where you are because they were excluded and they could not be on this jury. One of the reasons why you are sitting where you are is you said you understand the law and you will not require it. Because is there ever going to be a motive for someone killing two beautiful people as they sleep? The other thing that y'all said that y'all would do is you would not give the defendant more credit for being young. You would treat him like anybody else in the courtroom. Remember that? There are a whole lot of people who said, no, I'm going to give a better credit. I'm going to feel sorry. I'm going to have compassion, and I'm not going to be able to do it. I'm going to raise your burden. Remember those folks? They're not sitting where you are either. And let me say something about Rick Toto and his defense team. And I'm going to probably hurt a lot of feelings of lawyers in this courthouse, but I've never had an adversary more impressive than Rick Toto and his team, and I mean that sincerely. He's extremely talented and a good person. And I hope you are proud of the system we have here, because someone like A.J. Armstrong, accused of killing both of his parents, should have the quality representation that they gave him over the last 3 weeks. It is the way the system is designed. And make no mistake of it, Ryan and I have the burden and we gladly accept it, but they have the tougher job because their client is so clearly guilty. They spoke to you for 90 minutes talking about officers, talking about all this other stuff, but they didn't talk to at all about the defendant. Did you notice that? They both talked to you for 90 minutes about alarms and police officers, not once talking about the defendant. So I'm going to spend my time talking to you about the evidence and the defendant. Is that fair? By the way, when they talked about the lack of physical evidence, you know, the opening statement is like a contract. We tell you this is what the evidence is going to show, and you hold it to us if we don't. What Ryan told you 3 weeks ago is that the physical evidence is not going to be very helpful to you. Remember he said that? And he said it's because there aren't going to be prints. It's not like CSI. The DNA, everybody in the family is related to each other. So the DNA is not helpful. Everybody's got the same generally DNA, and that's what the expert told us. The blood spatter. You heard from one of the most renowned blood spatter experts in the world. And she said you would not expect there to be any blood on the perpetrator based on the gunfire. Remember that? So if there's no blood and no blood spatter, there's no blood in the home. And then GSR. He told you you're not going to get it on a 22. Yes, it was not 5%. It was up to 5%. Remember? Up to 5%. So that is why it's so small, you're not going to get GSR. That's not of help. So let's look into the evidence we do have, okay? First of all, days leading up to the murder. They have been exhausting trying to prove that Josh and AJ shared the room, and we now know they didn't, because he moved back from Glen and went straight to that apartment. And the reason why they think that's important is they know it's on this iPad. On this iPad, there is a Google search that is screenshot that says how to detonate a bomb to blow up a car. That very week, their parents end up dead. Do you remember when Nathan Gates told you and they had the download of the iPad? Do you remember what it said on the extraction? It said AJ's iPad. Remember that? Now, some of the younger folks in the jury will explain to everybody else, because I had to be explained to. That's the way iPads are set up. It registers you on the cloud as your name. This is not Josh's iPad. This is AJ's. In addition, look at this photograph. It's next to his bed, right next to the charger. How in the world can you say it's somebody else's iPad? But it's damning, because it's activity leading up to the murder. Then, 2 days before the murder, there's a rubbing alcohol bottle in AJ's bedroom. There is a burn mark on the top of the stairs. Kayra is staying at her grandmother's house all that week. The only people living in the residence are the Armstrongs and AJ Armstrong. Don't gloss over this. I need you to visualize this. He went with this rubbing alcohol bottle and went and got gasoline somewhere. He poured gasoline in that rubbing alcohol bottle. You heard from the expert, it had gasoline in it. He took that bottle, he went to the top of the staircase, and then he poured the gasoline across the carpet. And if it lights on fire like the movies, the house goes up in flames and the parents can't get out to go downstairs. We know that. And y'all have seen it in movies where they throw a match on the gasoline, everything goes up. But guess what? He's 16, he doesn't realize it doesn't happen that way. It's the fumes that have to light, and it kind of smolders out. But he can't get beyond. They can't get beyond. That's why they didn't mention in the 90 minutes they had before you what his intent was. I don't know why he did it. I don't know why he wanted to kill his parents, but we know 2 days before he wanted his parents dead. Everything you need to know. This is not a child playing with matches. This isn't someone saying, hey, well, it would be cool to be in the backyard and putting a toy on fire. This is a 16-year-old man pouring gasoline on the escape of their parents. You know what is in his mind from this alone. Again, don't know why, but we know what his intent was. And he acknowledges it, but then explains it away in AJ form.
How long ago was the carpet burned?
That was Tuesday.
Okay. What'd y'all put out?
That blue pillow that's right there.
Put out the pillow?
Yeah.
Did you spill anything on the floor before?
No, I didn't spill anything on the floor. That's the thing that was like confusing to me. I didn't spill anything on the floor.
What's the bottle of rubbing alcohol that's empty in your bedroom?
I don't know.
I'm just asking because the other investigator that was out there says that the floor right there smells like Excel, which is like some type of
Yeah, I know, like that, something like that. Yeah, right. That's what me and my dad, when like it happened, we both said that it like smelled like gas somewhere, and we didn't know where it was coming from.
I'll tell you where it was coming from. His bedroom. We know this now for a fact. But I guess he talked his way out of it. Then we have the crime scene itself. We have the windows locked, the blinds down. We have the back door locked, and we have the front door locked. We have the garage down as officers arrive. Folks, we have the murder weapon on the kitchen counter. In the history of murders, no murderer has ever left the murder weapon behind. There's only one reason why the murder weapon would still be in the house. Because the murderer is still in the house. if you just committed murder, you're going to flee the house with the weapon and throw it in the bike. The fact that the murder weapon is still in the home and A.J. Armstrong is still in the home, you know he did this. Then there's drawers pulled out. 4 drawers pulled out in the kitchen. Kind of staging like this is some kind of intruder. But the problem is, normal people, if you're going to go through drawers, you're going to open and close them. Or if you open them, you're going to just shovel them. These are neat. The drawers were neat, and they're pulled out, trying to throw off authorities. Then some kind of note, and the note says, "We've been watching you." So the killer is writing a note to the people he just killed. Does that make any sense? See, the problem is you may have a sick mind. You may want to carry these things out. You may be very good at talking and getting yourself out of trouble, but you're still 16 and not very smart. It just doesn't make sense. That note doesn't make sense. It's the things of movies. And that's why it was left, to try and throw off the authorities and try and throwing off you. So that crime scene alone tells us there's 4 folks in the house. 2 were shot. 1 is 12 years old and just woken up. And 1 person is still alive in the home. They make a big deal out of when the officers arrived at the scene, they came to the conclusion, the logical conclusion, that the defendant, 4 minus 3 is 1, the defendant, and they would say that that's wrong with the conclusion that those initial officers came to. Remember that? If officers arrive at that scene with the doors locked, the garage down, the windows closed, the murder weapon still in the home, and they don't assume it's this defendant, they should take their badges away. And you should be afraid. Now, obviously, there was more work to be done. There's more investigation. All they were saying is, we have to detain this person, see where they are. But again, remember, I'm going to talk about the evidence. We're there talking about everything else. We've already talked about the defendant's actions that week, both of the internet searching as well as trying to set the house on fire. Now let's look at his words, the defendant's words. Five hours later, he's down at the police station. He has been informed by a judge that his mom is dead. And his dad is in the hospital. And officers ask him about the family dynamic. I want you to pay close attention how this defendant, a 16-year-old male, knowing that his mom is dead, how he refers to her relationship with the family.
You get along with your mom, get along with dad, no problems, no issues. Yeah, like really close. And then me and my mom, like me, my brother and my sister, like had our like little issues with my mom, but it was never anything like serious. Like,
you just found out your mother's been killed. And you don't say, my God, she was wonderful. It was my mom. She was strong. She ran our household. What does she do? What do you mean? Of course she was amazing. Of course she got on me. I deserved it. Not A.J. Armstrong. He has to say something negative.
you get along with your mom, get along with dad, no problems, no issues. Yeah, like really close. And then me and my mom, like my brother and my sister, like had our like little issues with my mom, but
Actually, no. Kayla doesn't have issues with him. Josh doesn't have issues with her. The defendant has issues with her. Even in the moment that he realizes his mother is dead, he has so much disdain for her, he can't even say anything positive. You're attempting to get into the mind of a killer. This is what you have to do. Now, there's a real possibility, folks. Now, first of all, from the evidence, we know Dawn Armstrong was the first to be shot, right? Because as she lays sleeping, she has 2 bullet holes very close together, tragically. So we know she was the first to be shot. It's also why we know nobody from the outside did this, because the last thing you would do is go into the bedside table next to Antonio Sr., professional football player, grab the gun, go back around the bed, shoot Dawn Armstrong, then shoot him, right? And who in the world would shoot the woman first when the man is so big? Unless that's the person you went in there to kill. There's a real possibility that this defendant only intended to kill his mom, and when his dad woke up, he had no other choice. Right? And maybe this is what he meant on the 911 call when he says this. I don't know any other explanation. Then, keep in mind, he's on 911. He has called 911 under this fictitious idea, I need help, for 16 minutes. You would think if he had seen someone in the home, that would be the time to tell 911, right? I mean, like, the one thing, I guess, I hear gunshots, but if you see someone in your home while you're on 911, I don't care who you are. If you're a 10-year-old, you're going to say, I saw someone, please come, they're in the hallway. But he never says that, does he? For 16 minutes, the closest thing he says he hears gunshots, and this is what he says. My parents' door is cracked open, and it's never cracked open. That's the closest thing he says to seeing anybody during that 911 call. Y'all remember? He says he heard gunshots. That's why he called 911. If there is another person responsible, if there is another person in the house, wouldn't he have said it to the 911 operator? But he didn't. So it's the absence of saying anything that tells you there was nobody else in the house. But then, 5 hours later, he's down at the police station, right? Now, he's sitting down with homicide investigators. Is he going to stick with the doors cracked, the doors that never cracked, so clearly someone was there? No. He's a little bit more verbose now.
That's when I came down and I kind of looked, because you know how it goes down, like you can peek real quick and see like what's like going on from my stairs. And like I saw someone like coming out, so I just took off back upstairs and went straight to my closet, and that's when I called him.
So now it's not a crack. Now he's going down the stairs and he sees someone coming, but it's more.
Wait, did you physically see somebody?
No, I saw him running. Like I saw him running.
Now he sees someone running. You would think during a 16-minute 911 call, if he really saw someone running, he would have said, ma'am, I saw someone running in my house. Please get here. My sister's down the hallway. Wouldn't he have? Wouldn't he have said, someone's here, please. My sister is down the hallway. I see him running that way. But he doesn't do that. But to homicide investigators, if you're the only one in the house, if you're the one that committed murder, you've got to invent somebody. We all know from movies, the one-armed man, that's what this is like. But now it even gets thicker. Now, when they say, okay, well, what did the person look like? We can't give a description, so this is what he comes up with. A 6-foot masked man.
Is it he or she? Or?
It was definitely a guy. It wasn't a girl. There wasn't like long hair or anything like that. I mean, they had it was like a mask, and like you can only see the eyes and the mouth, but he looked like a black guy, but I'm not like 100% positive, but I'm pretty sure it was an African American, and like, I'd say like 6 feet, maybe.
Have you thought about how, if you're down 5 steps down from the stairs, as he says he was, as he's looking down, how he could tell he's 6 feet tall? He's just making stuff up. And again, if you were allegedly hiding in the closet and there's a masked man in your home and your sister is asleep down the hallway, you would mention it. And he didn't. And in fact, think about that 911 call. He says he hears gunshots, but he's on the 3rd floor. You would not be able to distinguish between his sister's room or his parents' room. But he knew it was his parents' room. Think about it when the 911 operator tells him the police are outside. He doesn't even go into his parents' room. He knows to bypass his parents' room and go straight to his sister's room. How does he know Kara is still alive? How does he know to tell the operator, I need to go get my sister? You know. It's because he knows who's dead. He knows who was shot. There's only one conclusion. Back to the weapon. Folks, the murder weapon is still in the home. The murder weapon is still in the home. 90 minutes of argument, they can't talk about that because they have no answer for that. I know all of you, but I know some of you fire guns. And there's this amazing thing is if you fire a gun without ear protection, something happens to your ears. Now, it wouldn't happen if you're in another room. The whole reason why we have ear protection is there's like a high pitch or a ringing that goes on in your ears. When the dispatcher asked him, do you hear any noises, what does A.J. Armstrong say?
Okay, can you hear anything else that's going on?
I do. It's not even like he's talking to her. He's whispering it low to himself. He's saying, it's high-pitched in my ears. This one statement is a confession. There's only one reason why you would have a high pitch in your ears is because you just fired a firearm inside of a home. Sometimes when you mumble to yourself, you sink yourself. Then the dispatcher asks, okay, because he says he heard gunfire, right? He heard 3 shots, 3 or 4. He says 2 or 3 shots. So she just asked him, okay, well, what kind of firearm is it? Is it a gun, a shotgun, a rifle? Remember that? Watch, he'll kind of hem and haw for a moment, but then immediately he will go to his dad's gun.
Does it sound like a handgun, rifle, or shotgun?
I'm not good out there. I know my dad has
Why is he talking about his dad's gun? All she asked him was a handgun, rifle, or shotgun. It's fine to say, I don't know. But he immediately started talking, right, about his dad's gun. Why is that? Because he knows his dad's gun, the one that was fired. Then you love how he goes, oh, where does he keep that gun? You know darn well he knows where he keeps that gun. Oh, wait, John, how do we know that? Well, there's more.
Do you know what kind of gun it is? I just know it's like a pistol. I think it's a 22, but I'm not like 100% positive. Like only time I've ever like used it was when we went to the gun range when I was like 8 years old or something like that. But like that's about it. And I know he has his case in one of his drawers. And like my dad, his drawers, the closet, and under the bed is like off limits. So like, I've never gone in there or like seen it or anything like that, except for when he brings it out. So like I don't know where he was keeping the gun at the time, but I know he keeps it on one of those 3 places.
So one, I haven't even touched that weapon for 8 years. And then not only that, my dad keeps it in different kind of places. I have no idea where it is. I don't want to tell you it's in the drawer, even though I know it's in the drawer. And so I can't tell you where it is. Let's flip it and say he's innocent, and he's in a police station, and he's being asked about the brutal murders of his parents. Wouldn't he be telling him everything? But he knows to say, I haven't touched that weapon in 8 years. He knows and is smart enough to realize, I don't know anything about that weapon. I don't know even where it is stored. That's what he tells us, right? But then,
in there, when you look up, there's a bullet hole in the ceiling that comes from the loft, which is your bedroom. It comes through the floor from the loft, from your room upstairs.
Yeah.
Where your room is.
The third floor. Yeah. There's a bullet hole in the ceiling.
yeah. Oh yeah, the third floor. And now you know what Don Armstrong's talking about. See, when we put in all those text messages, one, the dynamics of the family to show that they're frustrated with AJ. And believe me, we're not saying because you're a liar, you're a murderer. Absolutely not. But it puts this in perspective. When you hear him in this interview with homicide detectives, you can just almost see his brain working. How am I going to work this? Oh yeah, the hole in the ceiling. Okay, let me give you an explanation.
I think I played the gun from the room upstairs. It was like 2, maybe 3 weeks ago. Like me and one of my friends was just like playing around, and they were about to leave, and he was like, "Hey, well not really he. It was like me. I was like, "Hey, like have you ever tried that before?" And they were like, "Nah, I've never done it." And I was like, "Do you want me to show you how to?" And like I like went and checked in 3 places, and the gun was on my dad's bed. And I like laid the pillow. I laid my pillow and then like a blanket over it, a blanket under it, thinking like that would stop it. But I guess it did not stop it. Yeah.
Okay. So the first thing is he has to come up with the reason why he did fire the gun. And he says, 2 or 3 weeks ago. And the only reason why he did it is because he had a friend over. And the friend says, hey, look, you ever seen someone shoot a gun? Remember, that's the whole reason why he takes it out. There's a whole reason. But then when they ask him about this friend...
Let me ask you this. You made an interesting statement a minute ago about when you and your buddy were playing with your dad's gun 3 weeks ago, or whatever it was, 2 or 3 weeks ago, you said.
He was gone by the time I was playing with it. Like, we talked about it. That's like the conversation we had. I was the one that like...
So now, the friend, the whole reason why he brought out the gun, the whole reason why he's test firing the gun is because the friend had never seen it fired. So now he's got it out, and now the friend leaves and he still fires it anyway. But that was the whole reason why he brought it out. Are you understanding? Remember there used to be a show on television called Are You Smarter Than a Fifth Grader? Teenagers, 16-year-olds, are sadly capable of doing horrible things. But they're also 16, and they can't lie their way out of it. Part of our decision was picking 12 people who can look at the evidence. During jury selection, I asked you, when it comes to circumstantial cases, whose job is it to roll up their sleeves and figure things out? And you shouted, the jury. This is what you're doing. There is no other explanation to the stuff coming out of his mouth other than his guilt.
Let me ask you this. You made an interesting statement a minute ago about when you and your buddy were playing with your dad's gun 3 weeks ago, or whatever it was, 2 to 3 weeks ago.
He was gone by the time I was playing, but like we talked about it. That's like the conversation we had. I was the one that like.
So you said that you fired it into a pillow. Where's that pillow? What kind of pillow was it?
It's in my closet.
It's in your closet?
Yeah.
Like, you got like a bunch of doors in your room?
No, the closet, the actual closet. You're gonna see there's an A&M cover that has like a hole in it.
Okay.
Yeah.
And why'd you shoot it into a pillow?
Like I saw that in movies, I thought that like stopped the bullet. So like that's what I did.
Okay. You don't worry about your parents hearing the gun go off?
They weren't home.
No, they weren't home. They were at a fundraiser that night where he was alone. And what kind of movies is he watching that you can shoot into a pillow and it stops the bullet? There is only one reason why A.J. Armstrong took his dad's gun, put a pillowcase down, put a comforter down, and shot it through those items is because he had to test fire. He had to make sure the gun worked. He wanted to know how loud it was going to be, whether it would wake up his sister. That is the only reason why he had it in his hands beforehand. Based on him setting the fire days before, based on him doing the test fire before his parents ended up murdered, you know what his intent was. There is no other explanation. But remember how he said 2 or 3 weeks ago.
You're explaining away around that you shot to the floor 2 or 3 weeks ago when we've got fresh sheetrock on the ground and we've got a round still laying on the ground. I mean, your parents use that room constantly. They're going to notice. If your dad's going to notice a stem mark on the carpet, he's going to notice.
That's why I'm saying it doesn't make sense, because it wasn't in his past. I'm pretty sure it wasn't in his past week. If it wasn't this week, then it was last week.
Now it's not 3 weeks ago. Maybe it's this week. How about earlier that night? You can convict this defendant alone on the fact that the murder weapon is still in the home and he admitted to having it in his hands prior to, in nobody else's hands in Harris County at that time. You can convict him alone on the idea that first when he calls 911, there's a crack in the door, and now 5 hours later, there is a masked man coming from the bedroom. The evidence is pointing in one direction. And if you want confirmation that it just happened, he grabs socks and puts them over the hole in his room that night to prevent anyone from seeing the hole. What he didn't realize, there was a hole in the ceiling underneath him. If you want evidence that he knows what he did and he's covering it up, it's those pile of socks. I haven't even talked about technology yet. Where we are now, remember 90 minutes of just talking about cops, talking about DNA, talking about fingerprints that we told you we weren't going to have. Not 90 minutes. They didn't talk about the evidence. What do we have now? Before we even have technology, there is only one solution. This murder was committed by A.J. Armstrong. You have all of the windows locked. You have all of the blinds down. You have the back door locked. You have the front door locked. You have the garage down. You have the murder weapon still in the home. You have the murder weapon in this defendant's hands. He is test firing the murder weapon. You can convict him alone on what I've said before, the evidence. In fact, you're duty bound. There was the most powerful moment of trial. Do you know when that was? It was when y'all all got in this box, and on Monday morning, the judge asked you to stand up. And you all raised your right hand. And you said, a true verdict you will render based on the facts and based on the evidence. Other than the evidence of lawyers talking about a man with a mental illness and hoping that you believed that would be enough for you to pause, all evidence. All evidence points to one person. 11 out of 12 of y'all said you make most of your decisions based on logic. One of y'all is like me, and the three alternates are like me, is on your heart. Your brain and your mind is telling you what your heart doesn't want to accept. That someone could commit such a horrible act and be so young. But it's the undeniable truth. But there's more. These, first of all, are the phone records. Cell phone lock. You know he is on his phone constantly. Then at 1:02, he stops all cell phone activity. His phone is under lock as of 1:02. It will not be unlocked until 1:40 when he calls 911. He plugs in his phone at 1:04. He takes his phone out of plug at 1:08. Even us non-technology folks understand that. You have your phone plugged in next to your bed. There's only one reason why you unplug your phone. It's because you're on the move. Why else would you unplug your phone, right? So at 1:08, his phone is unplugged. You know from the crime scene photos he has sweatpants on with a pocket in it. 1 minute later, we know the sensor on the second floor that nobody has said is faulty goes off. Unplugs his phone, walks downstairs, goes off. Then we know that there's no other activity on that phone until he calls 911 at 1:40. And then he unlocks his phone and does that, and then he calls his brother. But there's more. Because during that time, between 1:02 and 1:40, his phone is still locked, but the display is going on and off, on and off. There's two possibilities. One, some push notifications will be coming through. Or two, you're walking through a dark house and you're using the ambient lighting to go through the house from your cell phone. Why else would the defendant's phone be unplugged if he was still in his bedroom? Why else would he be using that ambient lighting? and he certainly isn't using his phone. The only 30 minutes all week that the defendant's not using his phone, his parents end up dead. This confirms what you know from his own words, his own mouth. But then there's more. Alarm records. Ryan touched on this, but I want to bring it back to it. When they were trying to prove their point through their expert questioning, their argument was that the downstairs sensor should have been going off more, right? You remember when I asked him, right, I was like, well, are the sensors a little bit different? He goes, yeah, we actually report them differently. We even have lockouts and all that. It's the doors people care about. Their kids get out with the pool, people coming in and out of their home. Remember that? And the way sensors work is it tests body heat. That's different than a sensor on the door opening and closing, right? But how do they prove their point? Look, in these records, all 77 times that they allege in July that the bottom sensor wasn't going off, guess what was happening to prove their point? The doors were opening and closing. In the records, it shows door open or door closed, open, closed. Nobody has suggested at all that the doors weren't functioning correctly. And don't you know, if they weren't, you would have been told about it. So what do we see? We see in these records that the front door doesn't open until the defendant opens it for law enforcement at 1:57. It was closed when they came home. It never opened again. The next time the door opened was 1:57. Remember when you said you were going to base your verdict on the facts and the evidence? Lawyers walking through this door ain't evidence. Lawyers opening up a door, well, this might have happened, this might have happened, or an opening statement. That is not evidence. What you have to base it on is the evidence before you. And no one has challenged that the doors weren't working correctly. For those of you who have alarm systems, you know this. And in fact, you know the Armstrongs know it, because they use that system every single day, all the time, right? And if it wasn't working, they would have told you. The toughest thing, folks of Harris County don't pay my salary to pull punches. And I hope I complimented the defense and their team and how great of a job they did representing A.J. Armstrong as the system should be, is designed to be. And I hope Ryan and I have taken our job representing the folks of our community and come in here, and I hope you respect what we did, trying to give a voice to Dawn and Antonio Sr. But you don't want to believe this is true. You don't want to believe that a 16-year-old could kill their parents. You don't. And in fact, I venture to say, judges like this one, defense lawyers like these, and prosecutors like me, for years tell people, give defendants the presumption of innocence. And we hope they do. And here, you actually did. Because you would rather walk out of this courthouse and accept a truth that someone wouldn't be so capable of doing what he did. I know this. but you raised your right hand and you said you could do it. And as much as it may pain you, you know all of the evidence points to one person. The crime scene, his own words as he pretended to hide in a closet, his words 5 hours later to law enforcement. There is no other verdict. It's the cold reality that there are people who do the unthinkable. You know, you got thousands of text messages. And again, we weren't trying to disparage anybody, we just kind of give you a window into A.J. Armstrong and his parents. I feel like sometimes as a prosecutor in today's day and age, as we put text messages into evidence, I feel like we're kind of invading people's privacy. But it is pretty powerful because it's like they speak to us, right? You sit there, you were hearing it. You heard, like from these text messages, you kind of got a feeling of who these people were, right? You got this feeling that A.J. Armstrong's dad, Antonio Sr., big professional football player, Butkus, a finalist for Texas A&M, was a teddy bear. And was a soft one.
Objection.
He was encouraging. The text messages are clear.
Just a minute, Ms. Jordan.
It's a proper jury argument. It's outside the scope of the record.
All right, the jury will recall the evidence as overruled.
You heard his text messages with his son. Come on, bud. The encouraging nature that he was. You also kind of got to feel who Don Armstrong is. Kind of like my mom. Strong. Hold your kids accountable. Remember when she said, "Not in my house." Strong woman. Trying to be a great mother, right? So last night as I was sitting down, trying to determine what I was going to talk to you all about today, I wanted inspiration. So I sat down with all these text messages. They're all in evidence since April 1st. They're all in. And we just published. We published some, they published some to kind of give a feel. They published some good ones, we published some bad ones, right? But they're all in evidence. And I wanted them to speak to me. So as I'm reading these, in typical fashion, you know, A.J. Armstrong, he sneaks out of the house to see his girlfriend, as you saw in many of the text messages that Dawn is holding him accountable, right? Teenage kind of stuff. And she's confronting him about it. This is in April. And what I saw last night made my jaw drop. She says, "I know you left. The alarm doesn't lie. You lied. I can show you." Dawn Armstrong herself trusted the alarm system and was calling A.J. Armstrong out on leaving the house. How appropriate, 6 years later, that the last words of this trial will come from Dawn Armstrong. The woman who believed in justice and holding her son accountable. There are no words I can say, no phrases I can use that are more powerful, more appropriate, and more damning than that text message. It tells you what you know you have to do.
All right, ladies and gentlemen, you now have all the evidence in this case. When you retire to the jury room and when you request, if you do, your first piece of evidence, I will send it all back to you. Also, you've heard all the arguments from counsel, so I am formally giving the case to you for you to retire back to the jury room and formally begin your deliberations. Please retire the jury.
All rise for the jury.